A unanimous Supreme Court decision just dropped. 9 justices, 0 disagreement. And if you carry a firearm in your vehicle, what I am about to tell you changes the rules of every single traffic stop you will ever have for the rest of your life. I am not exaggerating when I say that. Most gun owners have no idea this happened. And the ones who do not know about it right now are the most vulnerable because police departments across the country are already updating their training based on this ruling. And if you do not know what changed, you could hand an officer a reason to search your car, seize your weapon, and charge you with a crime even if you did absolutely everything right. Here is what we are going to cover. First, the real case that went to the Supreme Court and what actually happened on that traffic stop. Second, exactly what 9 justices unanimously ruled and what it means the moment you are sitting on the side of the road with blue and red lights in your rearview mirror. Third, the 3 legal landmines that are still very much active even with this ruling in your pocket. And fourth, the 5-step protocol vetted by constitutional attorneys that creates a clean record and turns the Supreme Court decision into your best defense if an officer ever violates your rights. Stay with me until the end, because that last part is the part that actually keeps you out of handcuffs. And before we go any further, hit that subscribe button right now. Not after the video, right now. Because the legal landscape for gun owners is shifting faster than at any time in American history. And when the law changes, the government does not send you a memo. They send a patrol car. I do not want your first legal update to happen at 2 in the morning on the shoulder of a highway. Click subscribe, turn on notifications, and let us get into this. Let us talk about the case that started everything because this ruling did not come out of nowhere. It came from a real situation, a real traffic stop, and a chain of events that should make every law-abiding gun owner pay close attention. The case is Barnes versus Felix, and I want you to understand the facts because this is not some abstract legal exercise. This is what happens when a routine stop spirals out of control and the courts have to decide who is accountable. Picture a normal Tuesday. Someone is driving down the road. The stop is initiated over something minor. In this specific case, a toll violation. Not a chase, not a crime in progress, a routine stop. The kind that happens to millions of Americans every single day. The officer approaches the window. Now, in a perfect world, the driver provides their license, makes the required disclosure if the state demands it, and everyone goes home. But in the real world, things escalated. In the Barnes case, the situation turned deadly in under 2 minutes. The officer, Deputy Felix, ordered Barnes out of the car. Within seconds, the officer had jumped onto the running board of the moving vehicle, reached inside, and fired 2 shots. Here's where the legal trap comes in. And this is the part that should make every single gun owner's blood run cold. For years, police have used something called the moment of threat doctrine. Under this rule, which lower courts accepted for a generation, a judge would look only at the split second the officer pulled the trigger. They would ask one question at the exact moment the officer fired. Did he feel he was in danger? If the answer was yes, the officer was protected. It did not matter if the officer created the danger. It did not matter if the officer violated your rights 3 minutes earlier to provoke the situation. It did not matter if the officer's own reckless behavior turned a peaceful stop into chaos. The lower courts put on chronological blinders. They ignored everything that happened leading up to the confrontation. Think about how dangerous that framework is for you as a gun owner. If an officer sees your legal firearm, panics, and starts acting aggressively, jumping on your car, screaming conflicting orders, or reaching inside your vehicle, your instinctive reaction to that chaos could be used to justify whatever the officer did next. The system was designed to look at the end of the story and ignore the beginning. And it was spreading. Other courts were citing those decisions. Law enforcement agencies were building training around them until 9 Supreme Court justices said absolutely not. In a move that stunned the legal world, all 9 justices, from the most conservative to the most liberal, looked at the moment of threat doctrine and rejected it unanimously. Justice Elena Kagan, writing for a unanimous court, effectively tore up the old playbook. The Supreme Court ruled that the Fourth Amendment requires an evaluation of the totality of the circumstances. That phrase is the core of everything that changed. So let me make sure you really hear it. The totality of the circumstances means the blindfold is off. Courts can no longer look only at the second the trigger was pulled or the handcuffs clicked on. They have to look at the entire encounter. They have to examine why the officer initiated the stop. They have to consider whether the officer's own conduct unreasonably escalated a situation that never needed to escalate. For the first time in a generation, the Supreme Court told every law enforcement agency in America, you cannot create a dangerous situation and then use that danger as a shield for ignoring the Bill of Rights. The court went further. In their written opinion, the justices made clear that treating lawful gun ownership as an automatic indicator of criminal activity is not only legally wrong, it is constitutionally backwards. The Second Amendment exists precisely to protect the right to own and carry firearms. If exercising that right automatically triggers the loss of your Fourth Amendment protections against unreasonable searches and seizures, then the government has effectively made it impossible to freely exercise one constitutional right without surrendering another. The justices called this an unacceptable constitutional trade-off. Think about that language. 9 justices who agree on almost nothing agreed that what lower courts were doing was unacceptable. That word is deliberate. That is the Supreme Court sending a signal to every judge, every prosecutor, and every law enforcement agency in the country. Your Second Amendment rights and your Fourth Amendment rights are not enemies. They coexist, and the highest court in the land just made that the law. Now, before I get into what this ruling actually means for you when you are sitting in your car with an officer walking toward your window, I need you to do one thing. If you carry, if you travel, if you ever drive through a state that is not your home state, you need this information every single time the law changes. And it changes more than most people realize. Hit subscribe right now, turn on notifications, and let us keep going. Let us get out of the courtroom and into your car. Because here is the truth about Supreme Court rulings. They are just pieces of paper until an attorney uses them in a courtroom 6 months after you have already been arrested. Your job is to stay out of that courtroom in the first place. And to do that, you need to understand exactly what this ruling does for you and exactly where it stops protecting you. The ruling is a massive shift. Before this decision, officers in many jurisdictions were trained that a firearm disclosure automatically elevated a stop and gave them expanded authority to act. This ruling says that elevation alone, the simple presence of a legal gun, is not enough to justify a search or to excuse aggressive conduct. If evidence is later found during an unconstitutional search, your attorney can argue to have that evidence suppressed, meaning it cannot be used against you in court. A search built on the wrong legal foundation is exactly the kind of thing a skilled defense attorney uses to get charges dropped or dismissed. And now you have 9 Supreme Court justices backing that argument. But here's the part that most people are not talking about. And if you do not understand it, you are going to think you have more protection than you actually do. And that false sense of security could cost you everything. There are 3 legal landmines still very much active on the ground even after this ruling. And any one of them can turn your legal carry into a felony charge before you even realize what happened. The first landmine is the automobile exception. Most people believe the Fourth Amendment protects their car the same way it protects their home. That is a dangerous misconception. In the eyes of the law, your car is mobile. Evidence can be driven away. Because of that, the courts have long recognized what is called the automobile exception. If an officer has probable cause to believe there is evidence of a crime in your vehicle, they do not need a warrant. They can search your trunk, your center console, your locked glove box right there on the side of the road. The Barnes ruling requires courts to look at the totality of the encounter. But if you give the officer probable cause in the first 30 seconds of that encounter, the rest of the ruling becomes irrelevant. The totality will include that moment you gave them what they needed, which leads directly to the second landmine. The second landmine is what defense attorneys call the furtive movement clause. This is the single most common way that legal gun owners lose their cars, their firearms, and their freedom during a traffic stop. And it almost always happens because the gun owner was trying to be helpful. Picture the most common scenario. You get pulled over. You want to show the officer you are one of the good guys. So, you are nervous. Your hands are shaking slightly, and before the officer even reaches your window, you are already reaching toward your glove box for the registration or toward the center console where your carry piece is stored. The officer walks up, sees you moving around inside the vehicle, and in his report, he writes that you were making furtive movements. Under the old moment of threat doctrine, the court would only look at what happened when the officer decided to escalate. Under the new Barnes Totality standard, the court looks at everything, including those first few seconds when you were reaching. If the court decides your movement was suspicious, the officer's subsequent search or use of force may well be found reasonable. You handed them their justification on a platter, and you did it trying to be cooperative. The third landmine is the one that keeps attorneys awake at night, and it is the one that this ruling does almost nothing to protect you from. It is the multi-jurisdictional nightmare. If you drive across state lines and your carry permit is valid in your home state but not recognized in the state you just entered, your legal firearm becomes an illegal firearm the moment you cross that border. You might not realize it, the officer will. And the totality of circumstances at that point includes the fact that you are in possession of a firearm you are not legally permitted to have in that state. The Supreme Court ruling protects law-abiding gun owners exercising their rights lawfully. It does not protect someone who is by that state's laws committing a crime. This is the mistake millions of gun owners make every year when they travel, and it is the mistake that this ruling absolutely does not cover. Now, I want to give you something concrete because knowing the ruling is one thing. Knowing how to actually behave in the moment, heart hammering against your ribs, blue lights filling your mirror, is what actually protects you. What follows is a 5-step protocol designed to align precisely with the Barnes Totality of Circumstances standard. If you follow these steps, you create a clean record. If the officer still violates your rights after you have done everything right, this Supreme Court ruling becomes the hammer your attorney uses to get your charges dropped and potentially file a civil rights lawsuit against the department. If you miss even one of these steps, you may be handing the officer back the justification this ruling was designed to take away from them. Step 1. The moment you see those lights, start thinking about what the officer's body camera is going to record. Pull over smoothly and quickly. Turn off your engine. Roll down your driver's side window. Put your keys on top of the dashboard where they are plainly visible. If it is nighttime, turn on your interior light and place both hands at the 12-choir position on the steering wheel, fingers spread wide before the officer even opens their car door. Why does this matter so much? Because in Barnes versus Felix, one of the critical factors the officer cited was that the vehicle was still running and he feared being dragged. By killing the engine immediately and making your hands the most visible things about you, you are eliminating the vehicle as a weapon argument from the totality before the officer takes a single step toward you. You are creating what attorneys call a zero-threat environment on the record. Step 2. Do not move anything until the officer is standing at your window and has given you a direct verbal instruction. This is where most legal gun owners fail. The instinct is to have your license and registration ready. The instinct is to dig through the glove box before the officer asks. Do not do it. Every movement you make before the officer reaches your window is being recorded, and every movement can be characterized as furtive in a report. Keep your hands at 12 cow. When the officer asks for your documents, narrate every single movement before you make it. Say out loud, "Officer, my registration is in the glove box. I am reaching for it now. My firearm is secured in my center console. I have a valid permit." Slow, verbal, deliberate. You are not just talking to the officer. You are creating an audio record on their body camera that describes every action you take as transparent and intentional. That narration is the difference between a furtive movement and a compliant one. Step 3. Know your state's disclosure law before you are ever in this situation, not after. Some states legally require you to inform the officer that you are carrying the moment they make contact with you. Others do not require disclosure at all unless the officer directly asks. And a handful of states have specific rules about exactly how and when you must disclose. You need to know your state's rule right now today before you need it. If you are in a duty to inform state, Disclose early, calmly, and clearly. Something like, "Officer, I want to let you know I have a valid concealed carry permit and I have a legally owned firearm secured in my center console." Short, clear, hands visible, no rambling, no nervous over-explaining, no reaching toward the weapon as you mention it. That last part is critical. The way you disclose matters as much as the disclosure itself. Step 4. If the officer asks to search your vehicle, you have the right to decline, and you should know exactly how to exercise that right without sounding confrontational. The phrase that matters is this: "Officer, I respect the work you do, but I do not consent to any searches of my person or my vehicle." Say it calmly. Say it once. Do not argue. Do not lecture the officer about the Supreme Court, and do not repeat it multiple times. Under the Barnes ruling, the totality of circumstances must now include the fact that the officer asked for your consent and you legally and calmly declined. If they search anyway without probable cause, they can no longer claim the search was voluntary. They now have to justify it with articulable facts. And this ruling just made that significantly harder to do based on a legal firearm alone. If they do search anyway, and sometimes they will while training catches up to the law, do not physically resist. Say clearly for the body camera, "I do not consent to this search." Then comply physically. Save the legal argument for the courtroom. That is where this ruling does its real work. Step 5. The moment the stop ends, your job is not over. Document everything immediately before your adrenaline fades and the details blur. Write down the officer's full name, badge number, and patrol car number. Write down the time, exact location, and every reason the officer gave for the stop and for any search. Write down every word you can remember from the exchange as precisely as possible. If the officer said anything like, "I am searching because you have a firearm," write that down word for word. Because that officer just admitted to the exact conduct the Supreme Court ruled against. That statement, combined with a unanimous 9-2-0 ruling that says a legal gun alone is not justification for a search, is exactly the foundation your attorney needs to get your case dismissed and pursue a civil rights claim. There is one more thing you need to understand about this ruling, and it is something that is not getting nearly enough attention in the coverage. While the decision was unanimous, 4 justices, Kavanaugh, Thomas, Alito, and Barrett, wrote a concurrence. They agreed with the ruling, but they added language that you need to hear. They wrote that while courts must examine the totality of circumstances, they must also acknowledge the genuine and documented dangers that law enforcement officers face during traffic stops. This is the court's way of signaling that even under the new standard, judges are likely to give officers meaningful leeway when they can articulate specific reasons why a situation felt dangerous. This ruling tightens the standard. It does not eliminate officer discretion, which is precisely why your behavior in those first 30 seconds matters so much. You are not just trying to stay safe in the moment. You are shaping what the totality of circumstances looks like if this ever ends up in front of a judge. Let me zoom out for a moment because this ruling is about something bigger than one case or one traffic stop. For years, there's been a quiet erosion happening in this country, not through legislation, not through open public debate, but through lower court decisions that slowly and incrementally chipped away at the practical ability of law-abiding gun owners to exercise their rights without paying a hidden constitutional price. The logic crept forward in small steps. A gun in a car became a safety concern. A safety concern justified extra precautions. Extra precautions included searching the vehicle. Finding something during that search was called good police work. Each step sounded almost reasonable in isolation, but the chain of reasoning led to a place where having a legal firearm made you less free than someone who chose not to own one at all, where exercising one constitutional right meant quietly surrendering another. 9 justices saw exactly where that logic was heading, and they shut it down. Unanimous decisions from the Supreme Court are rare. They happen when the legal foundation is so solid and the error so clear that justices who agree on almost nothing else land in exactly the same place. This was one of those moments. And the message it sends is unmistakable to every lower court, every prosecutor, every police department, and every officer making a split-second judgment call on the side of the road. The Second Amendment and the Fourth Amendment are not in competition. They are both constitutional rights. They both deserve full protection, and the courts will not allow one to be used as a pretext to erode the other. Before I wrap up, there are 3 things I need to leave you with because a ruling like this can give you dangerous confidence if you are not careful. First, this ruling is now law, but implementation takes time. Officers on the street tonight may not know about it yet. Some departments will not update their training for months. You may still encounter officers who operate under the old rules and old instincts. Knowing your rights matters enormously, but knowing when to assert them in a courtroom versus when to stay calm and compliant on the roadside matters even more. Do not make the side of the road your battlefield. Second, this ruling protects people who are actually complying with the law. If your firearm has illegal modifications, if you are a prohibited person, if you do not have the right permits for the state you are driving in, this ruling provides you very little shelter. It is a shield built specifically for law-abiding gun owners, not a universal escape hatch for anyone who happens to be carrying. Third, state law still governs enormous portions of your life as a gun owner. The Supreme Court ruling addresses federal constitutional standards, but states retain enormous latitude in how they regulate firearms within those standards. You need to know the laws of every state you carry in, not just your home state, every state you drive through. That is not optional information. That is the difference between a lawful carry and a felony charge at a state line. You did not give a second thought. Here is the bottom line on everything we covered. The Supreme Court ruled 9-0 that a legally owned firearm in your vehicle is not by itself grounds for a warrantless search or for officers to ignore the conduct that led up to any use of force. The totality of circumstances must be evaluated. Your constitutional rights are not a pick-and-choose menu. You do not have to trade your Fourth Amendment privacy for your Second Amendment security. That is a genuine and significant victory for every law-abiding gun owner in America. But it is not a complete shield. Know your state laws. Know the disclosure rules where you carry. Carry your documentation. Be the most calm and cooperative person the officer has ever encountered. Narrate your movements. Decline searches politely and on the record. Never physically resist. And if your rights are violated anyway, document everything and take that fight to court with an attorney who knows what they are doing. This video is educational information to help you understand your rights and the current state of the law. It is not legal advice for your specific situation. Laws vary by state. Facts vary by case, and for any real legal issue you face, you need a qualified attorney, not a video. But understanding what the Supreme Court just decided, that knowledge belongs in your hands. And now it is. If this gave you something you did not know before you clicked play, do one thing. Subscribe to this channel right now. In 4 days, there is a video dropping that covers the 5 states most likely to turn your legal carry into a criminal charge the moment you cross their border. And one of them is a state that almost every gun owner assumes is completely safe. If you travel with your firearm at all, that video could be the most important thing you watch this year. Subscribe. Turn on notifications.